One turn and one yourself.
What's going on,
Yeah, I heard.
I have kids.
Call to order the June 2nd, 2022 meeting of the Planning Commission. First order is a Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next order is roll call. Luke, if you'd call the roll.
Yes, Millis. Looks like Diata is out or not present. Campbell.
Present.
Pearson.
Present.
Stolarski.
Present?
Hillenbring.
Present.
And McCauley.
Here. Thank you. Next order is the approval of minutes. Does anyone have any comments on the minutes from last meeting?
Move to approve the minutes of last session?
Is there a second?
Second.
All those in favor?
Aye.
All those opposed? Thank you much.
I'll abstain.
Oh, okay.
It wasn't,
Does it make sense since you were here?
I will abstain.
The Planning Commission review of new business, public hearing on the Animal Emergency and Referral Center, AERC LLC, the signage variance. Usually we first have one from the planner. I'm not sure which one of you are going to do the, Luke, if he'll give the report and then we'll call you up.
Okay, sounds good.
Thank you very much.
Yes, thank you, Luke McClanahan, the new city planner. This request is for a variance. The location is, the general location, as you can see, is 694, and here's its intersection with 10th Street. The property in question, if I can use my laser pointer here, is on the south side of Helmo Avenue. This is 1160 Helmo Avenue is the address. Folks might be familiar with the existing animal emergency center there on the north side of Helmo. This is a little bit of an older aerial. If you've been by the site, the building is under construction at this time. It's hard to miss. The request for this variance is to enable 5 additional wall signs on the property, and the additional signage is intended to help visitors on site, to help them be directed to seek emergency animal services. Here is a rendering of the property. So in the upper left-hand corner of this image is the west side of the building. As you can see, they are proposing, well, it's a little difficult to see in this image, but they are proposing 2 wall signs there. In the upper right-hand corner of this image is the east side of the building. 2 wall signs there. One is the logo for the hospital, and the other sign, it says pet emergency. The center image there is the north side of the building, and as you can see, there are 3 proposed wall signs there. And on the bottom side, or the bottom of this image is the south side of the building, where they're proposing 2 wall signs. So this property is zoned community commercial, and in this district, one wall sign for each street frontage is permitted on a building for each business located within such building. And if this variance request is approved, it would allow for this building to have a total of 9 wall signs. So again, that's 3 on the north side, 2 on the west side, 2 on the south side, and 2 on the east side of the building. And so none of the proposed signs would exceed the 150 square foot maximum allowed for wall signs in the commercial district. Here is a site photo of this property. This is the south side of the property, and again, it would have 2 wall signs if this variance request is approved. And this site photo is the north side of the building, here fronting Helmo Avenue, and again, 3 wall signs proposed on the north side. And here is the east side of the building, where they are proposing 2 wall signs. So this application meets the review criteria for a variance, and that is section 253700I of the ordinance as noted in the staff report on file. The applicant did notify neighbors and neighboring property owners within 100 feet of this site, and there were no objections. Staff recommends approval of this variance request, and the applicant is in attendance tonight, and I'd be happy to answer any questions. Thank you.
Thank you, Luke. I do have one minor question. I was in the process of trying to go through this, the city code to check, but is there any distinction drawn between, well, the one sign that is down low over the traffic, for instance, it's a traffic sign, basically. Is there any distinction between signs on the wall and signs guiding traffic in terms of those should be allowed or not, or without review?
So, no, there's no distinction there, that it's treated as a wall sign here, in this case, as it's attached to the building.
Okay. Anyone else have any questions?
None from me.
None from me.
Okay, then this is a public hearing, so I'll open the public hearing and ask if there's anybody who would like to come make comments. I know there's a couple ladies from the animal clinic.
Hi, thank you for your time tonight. My name is Heidi Brennigan. I'm the Chief Marketing Officer at Animal Emergency and Referral Center, Minnesota, and this is our CEO, Karen Reinhout. We have been in the community, have had the pleasure of being in Oakdale since 2000. We have about 350 employees, and we love where we're at. We have outgrown our previous location, which is why we built the new one. And this new building will be an emergency and specialty facility, and the current location will change into urgent care only. So there's a couple of reasons why we're requesting the variance. The first and most important one is that our hospital is really more like a human hospital than like another business, like a grocery store or a furniture store. It's essential that our clients be able to find us, and if you can kind of put yourself in their place, they're often coming at 3 a.m. They've got potentially a dying pet on the seat next to them, and so they're under a tremendous amount of stress. Most of them have never been to us before, so they don't know what they're looking for, and certainly with a brand new building, they haven't been to this one, even if they've been to our current location. It's just tremendously stressful, and they're looking for us in the middle of the night. So we really, the signs that we're asking for aren't really of a promotional nature so much as a directional nature. They just say pet emergency on the ones on the back so that they're lit up at night and people can find us. It's really the backside of Helmo that we're asking for the variance for, because all of the signage on the front of the building fits within the existing code. But the backside of that building, if you've driven by, is massive. It's about 200 feet long. And having just one sign in the center, we're a little bit concerned that people won't know that it's us, and that they won't know to turn into, where the movie theater used to be to get to the front of our building and enter. The other reason that we would really like the variance is because our current facility, like I said, has become to be known as AERC's emergency location, and the purpose of that building is transitioning to urgent care. So it's not even going to be open after 8 o'clock or 10 o'clock at night. So if we have somebody coming at 3 a.m, they're going where they've always gone, they may just go to that building, and we're going to designate to our clients either go to the blue building or the red building. And that's how we're going to kind of get in very simple terms through to people who have been to us before. So the current building has a very distinct blue sign on the front of it, and these signs will be red on that backside that say pet emergency. So again, we're just going to tap into that really simple part of somebody who's really stressed of their brain and just go to the red building. It's opposite, from where our current building is. So those are the biggest reasons that we're asking for this. And again, it's just critical that people be able to find us. With the incline coming up Helmo, it's going to be very difficult to see us, especially when the trees that are there are fully leafed. You can't see us when you're coming off of Helmo at all. I've looked. So when you're coming off of 694, onto Helmo, you can't see us. So we're hoping that that the signage will make that really clear for people who are in a tremendous amount of stress. Are there any questions?
Anyone have any questions for them?
This orientation that we're looking at, this is coming kind of north-ish from the Superamerica, is that right? I guess your business, you put the signs where you want to put the signs. Would it make more sense for one of these signs on the rear elevation to actually slip to the side there and go on the west, or I'm sorry, the east side?
Yeah, originally we did have on both, but when we heard that it was considered a different signage than our logo up top, we tried to pare them down. We'd be happy to put everyone there. So we tried to be subtle, so it's, they're small, they're only lit up at night.
Yeah.
But yeah, we'd love that.
Yeah, I think for me personally, I wouldn't have a problem with that if that was added. I think it's an appropriate location, and it's, as you said, it's not marketing, it's directional.
Right.
We've unfortunately had the pleasure of using your services, and I hope you know what I'm,
Of
obviously.
course, yes, we hear that a lot.
Yeah, and so I think you're absolutely right. When you're in that frame of mind, you want it to be clear and
Exactly.
easily understandable for people of where they need to go. So,
Right.
that's all I have.
Okay, the only question I have is, basically has no bearing on the signage at all, but, so your facility is basically a metro-wide, statewide, or what's the extent of your services?
It's actually really Midwest. We're the largest emergency and specialty center in the Midwest. We have people that come for our specialty services, even as far as the Dakotas, where they really don't have a specialty center. And then for emergency, since COVID started, really all of the emergency centers in the Twin Cities have been overwhelmed with cases, and that includes ours. And so we're all kind of punting for each other, whether it's the U of M or Blue Pearl or us. And so we're taking cases from all over. We get referrals from Wayzata, we get referrals from Duluth, we get referrals from Rochester.
So directional signs are going to be crucial to
They
get
really are, because like I said,
people in.
yeah, do we have repeat business from Oakdale and Woodbury? Absolutely, but we also have people coming from long distances who've never been to see us before.
Any other questions? Anything further from you, either of you two ladies?
Thank you for
Thanks so
letting
much.
Okay. It is a public hearing. Is there anyone else in the audience who would like to make any comments? Seeing none, I'll close the public hearing. Any final comments from the commissioners? On that, I'll call for a motion.
I will make a motion to recommend an approval of variance to allow 5 additional wall signs at 1160 Helmo Avenue North.
Second.
I'll second.
All those in favor? Aye. Any opposed? Any abstain? Thank you very much. Motion is granted. Please come up to the stand.
I'm curious. So we approved the 5, so we didn't approve yours.
That would be a different report and a different,
So we'd submit another application if we
different
wanted to do
application.
that. Okay.
Well,
that's-
and I guess Erin or Luke, we're a recommending body, we're not an approving body, so this will go to city council still. So could they amend this application before city council to add that additional sign?
Aaron,
it's
feel free
fine,
to
we
jump
don't
in
have
here. My feeling is, I'm sorry I missed it, but maybe the commission should amend their,
The issue with amending the application is that you'd have to have another public hearing to advertise what's
Fine.
being asked for, so it would need to come back before you
fine.
again.
Regardless, even if we,
If you requested something more than what they're asking for, yes.
That's fine. I just wanted to know what we do with that recommendation. Thank you.
your best thing is to meet with Luke afterwards and discuss a further motion. Thank you. Next on is a public hearing on Blooming Portraits LLC, Christina Knoche, and a conditional use permit for a home occupation. This is also a public hearing. We'll hear first from Luke on the report.
thank you. And this next request is a conditional use permit located in the southwestern portion of the city. As you can see here is the city boundary of landfall, and this property is to the northeast of that. This site is specifically on the south side of 3rd Street. It is addressed 6619 3rd Street, and the CUP is to allow a home occupation for a photo studio within a detached garage. Here's a look at the property there. This is the recently built detached garage where, again, the photo studio operations would occur. The property is zoned R3, that's low-density housing where home occupations are listed as a conditional use. A little bit of details on this business. Hours of operation would be 9 a.m. to 3 p.m. with sessions by appointment only. Typically, there will be one client per day occurring 3 to 4 times per week, and during summer months, most of the sessions would actually occur elsewhere, like at parks. The property owner is the only person employed for this use, and this request meets the general and specific review criteria of the ordinance as noted in the staff report, and therefore staff recommends approval of this request subject to conditions, and I'll just go ahead and read those 4 conditions. Hours of operation for the use shall be by appointment only from 9 a.m. to 3 p.m. Monday through Sunday. Parking for the use shall be conducted in a manner that does not obstruct the right-of-way. No more than one outside worker shall be employed for the use. And finally, all signage for the use shall comply with ordinance requirements. The applicant is here in attendance, and I'd be happy to answer any questions that you have.
Thank you. Anyone have any questions for Luke before I open the public hearing? Seeing none, I open the public hearing and ask for anybody who would like to make comments to come forward to the podium, please.
Hi, I'm Christina Knoche. I've owned Blooming Portraits for 15 years. My very first studio was in Oakdale, so I'm trying to bring it back into my home. I have children at home, and so during the summer months, it'd be very convenient for me to be able to do photo sessions in my studio. I mostly do newborns and babies, so it's not high traffic, and of course, I'll follow all of the rules that are required, so. I just appreciate that you're hearing me today.
Anyone have any questions? Okay.
Okay.
That's it, I guess.
Pretty straightforward. Thank you.
If there's anyone else in attendance who would like to come forward and make comments on this application, please do. Seeing none, I close the public hearing, bring it back, and if there's any further comments from anyone, then I look for a motion.
I will make a motion to recommend the approval of the conditional use permit for a home occupation photo studio at 6619 3rd Street North.
Second.
All those in favor?
Aye.
Any opposed? Thank you very much. Moving on to our other business, we now have a commissioner training hosted by Erin Perdu of Stantec.
This podium is an awkward height, so I'm going to stand up while I'm speaking because the chair makes the desk come up to about here. Good, we've got the presentation up. Nice to be back to see you this evening. I have some basic training to give all of you. I know that some of you may have had some planning basic training in the past. Since we have some new members, we thought it would be a good time to give you a refresher to make sure that everybody is on the same page. You've got copies of all of the slides and room to take notes if you like. Some of the slides have a lot of text on it, which I'll go through pretty quickly, so feel free to stop me and ask questions. I'm also going to pause periodically and just check and see if there are any questions on what I've just talked about. In the packet, I believe you got a copy of the Michigan chapter of the American Planning Association's Citizen Planner Manual. So that's just for your reference. I'm not going to go through the whole thing tonight, so don't worry. It won't keep you too late. But yeah, if you happen to look at it and have any questions about anything in there, you can always feel free to ask tonight or get in touch with me through Luke. Okay, and with that, the 4 topics that I'm going to cover tonight are the legal basis for planning and zoning, which is pretty brief, the roles and responsibilities of the Planning Commission as well as staff and the City Council, the rule books that govern what we do as planners, and then finally, uses and applications, which is what you spend most of your time dealing with here at the Planning Commission. Okay, so the legal basis for planning and zoning actually starts with the Constitution. There are principles in the Constitution relating to due process, equal protection, and takings. So basically, the idea here is that what we do is to make sure that everyone has a right to a clear process before the government takes any control over their property, that all people are treated in the same way, and that the government can't take all of the value of anyone's property without compensating them for it. So those are some basic underpinnings for the planning and zoning authority that cities have. We are also governed by enabling legislation at the state level. So the Minnesota state statute actually formally delegates planning and zoning to cities. And specifically, it enables city planning, says that cities have the right to guide their own future development. Some phrases that you'll hear frequently in planning reports are that we're looking for safer, more pleasant, more economical environments, and particularly it is the job of zoning to promote health, safety, and welfare. So a lot of times when we're looking at applications, we're making sure that what we're doing promotes health, safety, and welfare. In all of these actions, essentially what we're doing is balancing the common good, which is our police power authority, meaning that zoning has been deemed a valid police power, not actually literally using the police, but it's a valid power that cities have, versus individual rights that folks have to use their property as they please. So that was pretty quick, like I said. But any questions about that? All right, hearing none. We'll move on to the roles and responsibilities, and we're going to start with staff. So the role of your planning and zoning staff, your community development staff, is really to administer all aspects of the planning process. So they're the ones that have the initial contacts with property owners and developers. They obviously prepare your staff reports and basically give you technical advice to the city council and to the general public about issues relating to land use, planning, and zoning. So they are your professionals. They have been educated and trained in all things planning and zoning, and so they are here to be a resource for you and a resource for members of the public. What you're probably more interested in is your role. One of the things, in addition to reviewing all of these applications and making recommendations, actually one of the most important roles that you have as a planning commission is to prepare a plan for the community's future, and that plan is more commonly known as your comprehensive plan. So that's the primary responsibility of the planning commission, and so once that cycle comes back around in a few years, you will be knee-deep in preparing the comprehensive plan. You also prepare or direct staff to prepare and recommend zoning ordinance amendments from time to time as the city council authorizes. And then, of course, making recommendations to the council on all land use applications, which include comp plan. I think you've seen all of these in the few months that I've been here. Comp plan amendments, rezoning, subdivisions, conditional and interim use permits, variances, planned unit developments, and site plans, or combinations thereof. So this is, again, what you spend most of your time doing is really taking a close and thorough look at all of these applications and making recommendations to the city council. The city council does not and should not review all of these in as much detail as you do. And the city council, they are the sole legal authority in the city, so obviously they have the ultimate decision-making power over all of these applications, also the comprehensive plan and other plans that the city might undertake. And of course, the city council controls the budget. But they are the ones that decide on and take official action on all of those land use applications that you all review in detail and make recommendations on. So you've got your professional staff that's kind of the the foundation of the building. Then you have the planning commission that's getting technical assistance from staff and evaluating all of these things, holding public hearings, and making decisions and recommendations to the city council. So that's kind of how the flow of things work. Any questions on that? Again, these first two sections are quicker than the last two. Just warn you about that.
Go for the next.
All right, let's go for the next one. All right. So the rule books. So there are 3 rule books that we use in the planning process, and those are your comprehensive plan, the zoning ordinance, and your subdivision ordinance. Sometimes we forget that the subdivision ordinance is actually out there, and it's something separate from the zoning ordinance, but I'll just walk through what each of these 3 documents are there for. Your comprehensive plan is really the overall guide and vision for the entire community. In the 7-county metro, we're required to update our comp plans every 10 years. So that's what I was talking about when I mentioned the cycle. It is, again, a general guiding document. It's meant to be a broad brush policy. But the goals and objectives that are in your comprehensive plan form the foundation of the zoning ordinance. And the zoning ordinance is actually where the rubber hits the road, where we regulate what can happen on any particular use of a parcel. So common ways that you use the comprehensive plan are when you're evaluating a zoning map amendment or a text amendment. We often look to the comprehensive plan to make sure that it's consistent with the ideas and principles that are in there. We look to it to see whether things are consistent with the future land use map. So that's primarily how you use it on a day-to-day basis. But it also allows us to take a look at where sometimes proactively land could be rezoned, and the city could do that, again, proactively. That doesn't happen very often, but it can. The zoning ordinance. So really the main purpose of the zoning ordinance is to implement the comprehensive plan. So again, that's how the ideas and lofty goals in the comp plan actually get implemented. The source of zoning authority is that state enabling legislation that I mentioned a few minutes ago. And your authority is limited to what is actually adopted in the ordinance. So that means that we can only regulate insofar as we have adopted an ordinance to regulate something. It has to be written in there, is essentially what I'm saying. The standards have to be reasonable means to legal ends. So there are some limits as to things that we can regulate in the zoning ordinance. And your city attorney can advise you on that as well. But some of the ways that the regulations in the zoning ordinance are limited, the courts have said that zoning ordinances and any standards that are in there have to be reasonable, and they have to have a rational basis for regulation. Those terms are very intentional. They have been established by case law, and so basically whether something is reasonable and rational can be argued and is frequently argued in court. But essentially, if you're trying to protect health, safety, and welfare, which is back in that enabling legislation, whatever you put in your zoning ordinance has to have a rational basis that's related to that. So what can we regulate? Things that we do regulate are all kinds of things related to buildings, right? Sometimes it's down to materials. It could be as large as setbacks or location or even the number of buildings. We regulate lot coverage, yards or setbacks. Sometimes we use those words interchangeably, but basically where a building can be placed on a lot, residential densities, uses, of course, and parking, along with lots of other things like lighting and landscaping and all of that. Essentially, your zoning ordinance gets more specific than the comp plan. So we talked about a broad brush with the comp plan. The zoning ordinance is very specific to various parcels and gets into a lot more detail. In case you haven't seen it, this is the zoning map for Oakdale. It's pretty detailed, and I will not go through all of your zoning categories, but the legend shows you that you have essentially 3 commercial categories, maybe 4. You've got a couple of industrial categories, about 7 residential categories, and then a few miscellaneous. So quite a lot of detailed regulation in your zoning ordinance. So again, the Municipal Planning Act gives you the authority to regulate certain uses. Some uses are specifically limited. You're limited as to what you can do with these, limited by state law. So some of those special uses are manufactured homes. There are only certain ways that you can regulate those. You can't prohibit them per state law. Feedlots and earth homes, those don't really come into play in Oakdale very much. Those are more rural area things. But something that does come up are state licensed residential care facilities. And the state mandates these certain size limits to say, you know, you have to allow these in residential districts if they meet these size criteria. So, and again, the idea behind that is that they don't want cities to prohibit them. They've got to go somewhere. So there are a few uses like that where your planning authority is a little bit limited by the state. There are a few other laws at the federal level that limit zoning authority also. There's something that we like to call RLUIPA, or the Religious Land Use and Institutionalized Persons Act, which essentially says that you can't burden religious exercise, or you cannot overly regulate where places of worship can go and what standards they have to meet. There's also the Telecommunications Act, which basically says that you have to allow antenna towers and you can't prohibit wireless communication facilities within some boundaries. You have some control to limit them, but not a whole lot. And then, of course, the Americans with Disabilities Act and Fair Housing Act, which basically says that you can't have different rules for buildings that house people with disabilities. That's how it impacts planning and land use. So if a building is being used as a rehabilitation facility or something like that, you can't impose different rules on that than you would a building with a similar density that was used for something else. And again, that's per federal law. And then that ordinance that I mentioned, we sometimes forget about, which is the subdivision regulation. That's where we get into a lot more detail than even the zoning ordinance, where lot sizes are regulated. Zoning actually regulates lot sizes also. But it gets into details about streets, trails, park dedication fees. That's also in the subdivision regulation. There are design standards for your streets and all of that. And so when we look at a subdivision, we get into all of that level of design detail as well. Basically, the purpose of the subdivision ordinance is to make sure that new development meets the standards for safe, functional, and enjoyable places. So that's a little bit similar to that enabling legislation I mentioned earlier. More detailed requirements where we really get into the minutia. There are engineering standards in there. So things like streets, utilities, lighting, boulevards, public trails, all of that is regulated in the subdivision ordinance. And these zoning regulations and comp plans are written by planners, but subdivision regulations, we also let the engineers have a little bit of say in that, so that's why it's much more detailed. So any questions about the rule books? That was a little more information. Or comments about anything?
Seeing none?
I think the rule is to pause for 7 seconds and then you're allowed to move on, so. All right. That was more like 5? Okay. Well, we're a small group, so I can see all of you. All right. And finally, uses and applications. So The zoning ordinance goes into regulating uses in several ways. Most of the time, we're looking at what we call principal uses in the zoning ordinance. So those are the main or the primary use of a property. And principal uses include things like houses or offices or, warehouses or theaters or restaurants, whatever is in the building that is the main use of the property. We also regulate things that are accessory, so things that kind of go along with the primary uses, but we still have to list them to make sure that they're allowed. So things like garages, which go with houses, or parking lots, which go with commercial establishments. Accessory, when we say ADU, that's an accessory dwelling unit. We do allow those in Oakdale in certain zoning districts, and those are accessory to the house. So those are basically things that are subordinate to the principal use on the property. We have language in the zoning ordinance that says you can't have an accessory use without having a principal use. So you can't build a parking lot on a lot that doesn't have a building on it, doesn't have a principal use. You can't build a garage on a parcel that doesn't have a principal use like a house, things like that. So then we group those primary and accessory uses into permitted uses and conditional uses. And so the permitted uses are all of the things that you can do by right on a property. So when we hear somebody say this is allowed by right, it means it's listed as a permitted use in the zoning ordinance. So a property can be used for these things without any special approvals needed. So in your residential districts, you can build houses without having any special approvals. In your commercial districts, you can build restaurants without having to come for special permission, things like that. But then there's another level of review with conditional uses, and those are uses that are still considered permitted, but there are some additional standards that they have to meet. And things like that include drive-throughs are very common in cities, or gas stations. So you might allow retail establishments, but if you want to have a drive-through, that's a conditional use because the city wants to have a little bit higher level of review, want to be able to establish some more conditions on those. Things like light industrial buildings are allowed, but perhaps a distribution facility or a trucking warehouse, something that generates more traffic than a typical light industrial building, you might want to have an extra standard of review. So basically, those are uses where they do come before the Planning Commission. They do require public hearings, and you are allowed to establish additional conditions on those uses, generally because they have the potential to have more impact on their surroundings than permitted uses do. And the last type is an interim use. So interim uses are interesting. They're like conditional uses, but they are temporary, as the name implies. Basically, interim uses, you can attach a time frame or an expiration on something that you want to have tied to a particular business or a particular event. Things that might include, for example, you allow a use like a mini storage until something else is built, or a solar farm that has an end date to the lease. One of the most common ways we see these in Oakdale are the outdoor play areas for doggy daycares, which we just looked at a couple of months ago. And the reason that those are classified as interim uses is because we want that permit, that interim use permit, tied to the business. We don't want it to run with the land and be there forever if the business that it's associated is no longer there. And I'll talk a little bit more about that in a second. Legal nonconformities. This is what people affectionately refer to as grandfathering things in. The general rule for legal nonconformities is that if something is lawful at the time of the zoning ordinance, If the zoning ordinance changes, that use can still stay there. So if this happens a lot with residential properties on major thoroughfares. Perhaps the city rezones the entire corridor for commercial use, but there are still a few houses there. So the houses are non-conforming. They don't match the zoning ordinance anymore, but they're allowed to stay there because they were legally there to begin with. The zoning ordinance changed, but the use didn't. And so that means that they are grandfathered and that they can stay. So again, the uses or conditions that precede the zoning ordinance, they're allowed to continue, but they're also allowed to be repaired, maintained, replaced, or improved. So you can do a lot of things with a non-conforming use or a non-conforming building, but you can't expand it. You can't expand the use or whatever's non-conforming about it. Perhaps it's non-conforming with regard to the setback. You can't expand that non-conformity. You can't build further into the setback. So you can fix things, you can make sure you maintain them so that they can be continued. They can even be replaced if they're destroyed by putting it back in the same location and the same size. They just can't be replaced bigger than they were before. State law has a bunch of language related to nonconformities. So they require uses to become conforming when they are discontinued for a year. So if you have a duplex in a zoning district that doesn't allow duplexes, if it sits vacant for more than a year, it can't be used as a duplex again. It has to be used as a single-family home. That's one of the more common things that we see. And the language about getting destroyed more than 50% of the market value by fire, if it looks complicated, that's because it is. It's in the state law and lawyers wrote it. But basically, if something is damaged more than 50% of its market value and nobody applies for a permit to fix it within 6 months, the non-conforming status goes away and it has to be rebuilt per the ordinance regulations. So I'm going to pause there for a second before we get into the actual applications and see if you have questions or things you'd like to discuss about uses. I'll talk a little bit more about conditional versus interim when we talk about the permits. But
With the grandfathering thing,
yeah,
say somebody's got a business and all of a sudden we change it to multifamily only, so the business is there.
okay.
They can't, according to that, they can't expand or anything like that. Now, since it's their business, they already own it, and we're gonna take their means of making income from expanding it, isn't that considered a takings in a sense?
A taking, there's pretty strict criteria for calling something a taking. You have to take basically almost all of the value of the land. So if you rezoned it from commercial to park, that would be a clear taking. If you're rezoning it to multifamily, you could argue that there's still a lot of money to be made on a multifamily property. I think good planning practice is that you wouldn't do that. You wouldn't proactively rezone something from a business to a like a residential use for that exact reason. You don't want to put people in a bind. Businesses often have, they have expenses that they take loans for, and if they don't have the right zoning, they can't get loans. So generally, you just don't do that. It's more common for something to be rezoned from residential to either mixed use or commercial, and you have to write in, that's when the nonconformity thing comes in handy to allow the houses to stay there. More often than not, we don't see non-conforming uses. We see non-conforming structures, meaning they're too close to the property line or something like that. Okay. All right. Well, then, applications. This is the pyramid of discretion, which planners like to use a lot. But we've talked about basically each of these things except for the building code, which is at the top. So the level of discretion, your amount of discretion that you have gets smaller and smaller as you go up the pyramid. The city has a lot of discretion when it comes to writing a comprehensive plan, because that's your chance to set out what's your vision, what do you want to see in the future for the city of Oakdale, and that could be pretty much anything within the confines of the Metropolitan Council, but that's a whole nother training session. So you have a lot of discretion when it comes to adopting your comprehensive plan. It gets a little bit narrower when you get to zoning and rezoning applications, because again, your zoning ordinance has to be consistent with and reflect your comp plan. When you get to variances, subdivisions, and conditional use permits, there are some specific criteria by which those have to be evaluated, so you have a little bit less discretion when you review those, because you have to use the standards that are in your ordinance and that are in state law. Site plan review is really a quasi-judicial action, because your ordinance lays out very specifically the criteria for things like that you review in a site plan: parking, setbacks, circulation, landscaping, lighting, all of that. And if a site plan comes in and meets all of those standards, you're obligated to approve it. If you don't approve it, then that's a problem, which is why it's very important to put the effort into getting your zoning ordinance correct, because then you're pretty much tied to that. And building permits are administrative, so you don't even see those. They're regulated by the site plans that you approve and then by the building code. So it gets more administrative as you go up the pyramid. So let's talk about some of these. Conditional use permits. So in order to approve a conditional use permit, the basic criteria that you have in your ordinance are that the use has to be compatible with the existing neighborhood or the surrounding properties. It has to conform to the comprehensive plan, so that's another time that you refer to that. It can't endanger public health, safety, and welfare, so that comes from our enabling legislation. And it has to meet any other standards if they exist in the zoning code. So for example, drive-throughs often have additional standards, like you have to have a certain number of stacking spaces, or some businesses that are special uses have limits on the hours that they can be open, things like that. Once you grant a conditional use permit, you can't revoke it unless there's a violation of those criteria that, or any conditions that you put on it when you approved it. So conditional use permits can be revoked, but in general, they run with the land. They're attached to the property, and so that use can stay there forever. One that you just reviewed a couple months ago was a church. Churches are allowed as conditional uses in residential districts. So even if that church, goes away, another church could come in and occupy that property because the conditional use stays there with the property. Interim uses, on the other hand, are not attached to the property. They're attached to a specific time limit or a specific business. So the criteria are really very much the same as with the conditional use permit, except that there has to be a specific date or event or instance where you can see that you might want to set a time limit on it. So for the doggy daycare thing, you don't want the outdoor dog play area to stay there if the doggy daycare business goes away. So the interim use permit would expire if the business ceases to be there. That's the reason that we use it for that. But otherwise, the criteria for approval are pretty much the same. So again, some examples, again, those outdoor play areas, any use that's associated with a particular business or a particular event. So if you had a festival or something and you wanted to approve, a parking lot full of food trucks, let's say, that might be something you would attach an interim use permit. So you cannot limit the time of a conditional use, but you can with an interim use. So that's why we've got both of them in your ordinance. There might be times when you'd use one or the other. That one was a little bit complicated, so I'll stop there and see if there's any questions or comments.
Not a question there, but on the previous one, the attaches to the property and then in parentheses, you said should be recorded. So those go to the county for the inclusion in the abstract?
Yes. We do send this.
the one we just, this Blooming Portraits, that will be with that house forever. So when she sells her house, she can say, I have a running business. You can run a running business in your garage.
I think that Luke can help me out here, but that was a conditional use permit for a home occupation. Is that right?
That's correct.
Exactly.
Yeah.
Right. So yes, so there's an approval for a home occupation there. So someone else could do the same thing. Now, if someone else wanted to do a different occupation or they needed expanded hours or something, they'd have to come back for a new.
But it still is with the house now forever.
Correct. Yep. Some cities deal with home occupations as interim uses rather than conditional, or they have some parameters about just allowing them administratively so that they don't even have to come before a commission, so. All right. Okay, well, variances. There's a lot of case law and a lot of language about variances in our state enabling legislation too, but basically, variances have pretty high standards in order for someone to be granted a variance because they're asking for permission to depart from the rules that are in our rule books that we talked about. The basic standard that needs to be met is practical difficulty. So years ago, we used to say that someone had to prove a hardship. That is no longer the standard because of case law and changes in state law. What they need to prove is that they have a practical difficulty to meeting the standards that are in the zoning ordinance. So again, this language comes from state statute, and these criteria that I'm going to show you come from state statute, so they have to be followed by the city. So variances may be granted, but they are not required to be granted. The city has to find that there are practical difficulties, and there's basically 3 pillars to proving a practical difficulty. You have to prove, the applicant has to prove that they're going to use the property in a reasonable manner. So the use itself has to be reasonable. That there are circumstances that are unique to the property that are not caused by the landowner. So if you built a house, for example, that was right at the required setback, and then you came back later and asked for a 5-foot variance because you wanted to put a deck on the side, that would be a circumstance that was caused by the property owner, and you'd have to say, well, you don't meet that criteria. It's a little bit different if you purchase a house that is already, you get that all the time, right? People buy houses and they want to add on or do something and they request a variance. That's different because they didn't create the circumstance, the previous owner did. But if they create it themselves, that's a problem. And of course, the variance can't alter the essential character of the locality, meaning the surrounding area. So whatever you're granting, that's a pretty subjective one. You just have to make sure that it's within character of the area. So let's talk about what does it mean that you're going to use the property in a reasonable manner. So that means that the owner wants to use the property in a reasonable way, but can't do it because of the rules of the ordinance. I can think of a common example where someone buys a home that was maybe built in the 50s and only has a 1-car garage. And they want to expand it into a 2-car garage, which is pretty reasonable and typical for houses nowadays. But there's something in the zoning ordinance that prevents them from doing that. You could say, okay, a 2-car garage on a single-family house is a reasonable use. If they wanted to do a 4-car garage, you might say, that's not reasonable. There's no reason that you have to have that. So again, it doesn't mean that the land can't be put to any use without the variance, but just that the request is reasonable. And reasonable is, a little bit subjective, but you're chuckling. I'm going to ask you to share you have a variance experience.
No, I'm just sitting here thinking of my 2-car garage that I'd really like to have a 4-car, but that would be on my neighbor's property, which wouldn't work too well. But
Right.
I can think of a number of reasons why, yes, I really would like to have that 4-car garage.
Well, I can think of a lot of reasons too, in which case, you might want to get a bigger lot or something like that. So the unique circumstances thing, that means that we're talking about the physical characteristics of the property. There's something unusual about it. Maybe the lot is smaller than others in the neighborhood, or it's on a corner at an odd angle, and so the setbacks really reduce the buildable area of it. Or there's something else physically like trees or slopes or a wetland that impacts what you can do with the property. Those are unique physical characteristics, unique circumstances. Economic considerations alone are not unique circumstances. So if an applicant says, well, you know, it would be a lot more expensive for me to do X and meet the ordinance, so I want a variance to do Y instead, if the economic consideration is the only reason for the request, then that's not a valid reason to grant one. A lot of times, economic considerations are bundled in with other things, but primarily it's your job to evaluate a request without, you know, kind of setting aside the economics and looking at whether there's a unique circumstance and whether the use is reasonable. And finally, the character of the neighborhood. So this is a tough one. This is also when you often get a lot of folks showing up for your public hearings and voicing opposition to requests that come in. And so what we do in these cases is we look at, you know, is the result going to be out of scale? Is it going to be out of place? Is it going to create impacts to surrounding properties that are unreasonable? Those could be created by height, setback, shape, size, building orientation, any of these things. So that's what we look at when we give you a staff report to basically figure out whether this is within the character of the neighborhood. And in general, you can put conditions on variances, and we have done that before, but they have to be directly related to and bear a rough proportionality, that word comes from case law, to the impact that's created by a variance. So for example, if you grant a variance for a setback, you know, a building can be closer to the lot line than it's allowed to be. You might put a requirement that there needs to be more screening between that building and the property line. What's not reasonable is to add a condition on the other side of the property, like there's something else you don't like about the site. You can't add other conditions. They have to relate specifically to the variance that's being requested. And another thing that comes up a lot when we look at variances are, you know, well, my neighbor down the street got one, and there are 5 other lots in the subdivision like this. Precedent, you can't say that a pattern of granting variances is a precedent, because each individual application has to be similarly situated in facts and in time. So unless the properties are identical, you can't necessarily say, well, we have to grant this because we've established this precedent. I'll point out that use variances are not allowed in Minnesota, so someone can't come in and request to have a Taco Bell in the middle of a neighborhood, because that's just not allowed, and Minnesota doesn't even allow you to evaluate use variances. And lastly, errors by staff do not entitle a person to a variance. So, you know, even if something slips through the cracks and gets approved and a neighbor says, hey, you know, their deck is too close to the lot, or their fence is too tall, or whatever, and they come before you for a variance, that just because there was an error doesn't mean that you have to grant the variance. That doesn't happen very often. Staff are pretty good at not doing things like that, but it does once in a while. In other cities, not here. Questions about variances? There was a lot of stuff in there. I think in general, what I've seen since I've been here is that you guys handle those fairly well. Some cities have a pattern of just granting them all the time because they don't want to deal with upset property owners, but I think you guys have been very reasonable in your evaluation of these things. All right. Zoning ordinance amendments. So those can either be map changes or text changes. Usually a text change comes from the city council wanting to change something, or the planning commission identifying an issue that we want to fix. And map changes usually come from property owners. They want to change from one district to another. In order to approve a zoning ordinance amendment, whether it's text or a map, again, it has to comply with the comprehensive plan, and it has to be able to be accommodated without burdening the city's public services. So that's kind of a unique one when we look at changing the uses that are allowed on a property by changing the district. For example, you have to make sure that the infrastructure and the city services can handle that change. Whenever you're looking at a rezoning, whether it's a map change or a text change, there is a greater burden on the applicant than on the government to change the zoning. So applicants really need to prove that it's consistent with the comprehensive plan. We don't allow spot zoning, so basically you don't want to create a small island of one particular district in the middle of something else. And so you need to make sure that there's a fairly reasonable pattern of your zoning districts. Something that you may not know is that if you're changing something from residential to commercial or industrial or anything non-residential, that requires a 4/5 vote of the city council. So not a simple majority. Again, because that's kind of a big deal. And obviously you can't change the rules ad hoc. You have to amend the zoning ordinance per the procedures in state law and that are in fact in your ordinance. So there's a whole public hearing procedure to change the text of the ordinance too. And the final type of application is a comprehensive plan amendment. So a lot of times these go in combination with other things. For example, one of the applications you had recently was at the Forefront planned unit development. They wanted to change the uses that were allowed in the PUD on one of the parcels to include mixed use where a business park was planned before. So that involved a comprehensive plan amendment to change the future land use designation. It involved amending the planned unit development, which is an ordinance amendment. And then I can't remember what else was involved in that application, but a lot of times those kinds of things go together. If there is ever a conflict with the zoning ordinance and the comprehensive plan wins. So that's important. So important that we have it on a special slide. If there's a comprehensive plan, if there's a conflict with the zoning ordinance, the comprehensive plan wins. So if this is why your zoning map and your zoning text has to reflect the comprehensive plan. So if your comprehensive plan map shows something as, commercial, but the zoning ordinance has it zoned for residential, a person has a right to use that for commercial, like the city is obligated to update the zoning ordinance to reflect the comprehensive plan is basically what we're saying there. So again, the comprehensive plan is the base of that pyramid where you have a lot of discretion, and that's why it's really important that you spend the amount of time to get the comprehensive plan right and make sure that it reflects what you want to see, because then you're bound to it by several of these applications. All right. The last thing I'm going to cover is an administrative thing, which when I moved to Minnesota about 8 years ago, this was news to me, and I actually really like it. It's your 60-day rule. Yeah, I don't know if they have that in Iowa. Yeah.
Not quite, no.
Not
it's
quite.
A little bit different in Iowa.
Yeah, I came from Michigan where land use applications would languish for years. With, cities just kind of saying, we don't like this, go back and change it, and it would just go around and around. Here, the state mandates that we take action on things within 60 days. There's a couple of additional things in there, like staff has 15 business days to determine if an application is complete. So the clock doesn't start when someone turns in an application. It starts once staff deem it complete. And there's a 15-day time period where they have to review that and make sure that it's all of the information is there. If something is incomplete, staff has to state that in writing and state the things that are missing. in general, the 60-day rule, once something is deemed complete, the clock starts. And if the city, if it doesn't make it all the way through the process to city council action within 60 days, the application is deemed approved. So that's an incentive to make sure that things get through the process on time. It's not uncommon for the Planning Commission to take 1 or even 2 meetings to consider an application. A lot of times, if something's complicated or you want to see changes, you'll table it, the applicant will go away and come back. There's generally time in that 60-day frame for like somebody to table it and for it to come back. But if the city decides that we need more time, we have the ability to extend the clock another 60 days with written notice to the applicant. So if it's a particularly complex application and we need more time to review it, we can send them a letter and say we need another 60 days. That's it. We can't extend it any further than that. So 120 days is really kind of the drop dead unless the applicant says we want an extension. That sometimes happens if an application is very complicated. We get close to the end of the 120 days and either you or the city council are not satisfied with it and you say, well, we're going to have to deny this because we haven't resolved some of these issues. The applicant will often say, okay, I'm going to extend the time frame. Let me take some more time to work on this and come back. So that's pretty common too.
Is that what happened with the church?
Yes,
Okay.
I believe it did. We extended the 60 days, and I think I don't remember if that had to get extended again.
I don't recall.
Yeah, I don't recall, but
City council, did they?
It got approved.
It did get approved, so
The
it
church.
did not get extended then, because of the parking situation.
We granted the variance.
okay. Yeah, we did advise them, I think, before that meeting that, if the city council is going to deny you, you may want to request an extension and go back to the drawing board.
That was it, yeah.
Yeah, so they didn't do that, but they could
One
have.
quick question, did they get legal with the,
No, we did not go with that. They came back with additional parking in the church parking lot. They came
Okay.
up with more, and then we allowed them to be less than what the requirement was.
Okay.
So it was like a compromise. So that's how it ended up,
okay,
okay?
because we didn't really.
Right,
We didn't
right.
have a meeting last month, so I just
Yep.
was wondering what had happened there.
Yep, no, that's a great
Do you
question.
have any questions on that?
My question actually is on the 60-day rule. Is it
Sure.
calendar days or business days?
60 days are calendar days. The 15-day review period for completeness is business days, but the 60 days are calendar days.
I was talking to a civil engineer yesterday while I was in Phoenix about the 60-day rule, and it blew his mind.
Yeah, it's not even business days. It's like, 2 months, that's it. So basically 2 meeting cycles,
Yeah.
and you got to be through it. The thing that's complicated when we lay out the application deadlines and all of that based on your meeting calendar, there's also requirements that I'm going to talk about with public hearings where you have to publish notice 10 days before a meeting and mail out notices, and so you have to build in that time plus the incomplete review, the completeness review time, and
So let me ask another question
Sure.
about that. So on a lot of my projects, it's not uncommon to go 3 or 4 rounds with a city, and I mean, I'm primarily working in the Southwest US.
okay.
And so, they'll take 2 months to review before they get me comments. And then I need 4 to 6 weeks to pull together everything and respond to that. How do we deal with that with applicants when you go back and say, yeah, your application is complete, but A, B, C, D, E is wrong. You need to adjust your application. Does that restart the 60-day clock then? Or do they have to, they could take as much time as they want as.
Doesn't sound like it was complete, actually, at that point yet.
It's not that it wasn't complete. They had all the pieces in,
Right.
but it just doesn't meet the standards.
Right.
Like the zoning
That,
code.
usually in those cases, we will advise them, like your application's complete, but it doesn't meet our criteria, so we're probably going to recommend denial unless you want to take another look at it. Usually we address those kind of things in the pre-application conversations that we have with developers, so it doesn't usually get that far, like something hits the desk and it's like, what is this? It doesn't meet our criteria. But yeah, usually in those cases, if the applicant says, well, I'm gonna need, a month to turn this around, we'll just extend the 60 days. It's pretty rare that they will request another extension unless it's something big that they need to fix. All right, so public hearings. All these applications that you typically deal with require public hearings, plats, land use applications, zoning amendments, and comp plan amendments. We are required to publish notice, as I mentioned. It says in an official newspaper of circulation in the community. I don't know when that's going to get changed because local newspapers are getting fewer and far between all the time. In some communities, in some small communities, the newspaper publication can really put a constraint on the 60-day. If they only publish once a week, you're really constrained by that. But the notice has to appear at least 10 days in advance of the meeting, and in Oakdale, we mail notice to everyone within 500 feet of an applicant's property. The state statute only requires 350 feet, I believe, but we go a little bit beyond that in Oakdale. And again, just like you did tonight, you allow public comments at the hearing. This is important, again, because due process. So I won't go into this too much, but again, it's something that's guaranteed by the Constitution, and this is why we do it. After a public hearing, it's really important that when you make a recommendation and then the city council makes a final action, that you adopt findings of fact. And those findings of fact articulate the basis for your decision. And if you approve or deny something, the applicant is clear on why it was approved or why it was denied. So that's why when you get a staff report, the staff report reviews all of the criteria that are in your ordinance. The staff report will include conditions, recommended conditions, and then we give you a draft resolution that the council would adopt also. And so all of those documents communicate the findings of fact. So usually when you make a recommendation like you did tonight, you just say that it's per the sample ordinance and per the staff report, and those are your findings of fact. If you're going to take a different direction, it's important to articulate what your findings are so that staff and the council can get those down on paper when they're adopted. So a few examples of good findings of fact to put in your motions and your resolutions, that things are consistent with the comp plan, that they're not going to detrimentally impact surrounding properties. If you're looking at a variance, your finding is that there is a practical difficulty. And you state pertinent facts in those resolutions. So if you look at the resolutions, we often talk about whatever's relevant to the application, the location, the size, the use, that sort of thing. So those are the things that you want to rely on when you're making findings of fact. They're related to the criteria for whatever application it is. Things that are not valid findings of fact or not valid reasons for approving something. You like the guy. I mean, this sounds funny, but it comes up a lot in, in communities. Like, the person is well known, they've lived there a long time, or they're a long time business owner, so they know they're good for the community. That is not a valid reason to approve or deny something. That the owner says they can't sell the property unless you grant them whatever approval they're asking. Or they've already spent money assuming that you were going to approve an application, or maybe they didn't know they needed approval. All right, that happens a lot. Like, they spend money with doing something or applying for a permit when they don't know they need a variance. That is also not a reason to approve something. If you're going to deny an application, you could say that it's not consistent with the comprehensive plan. Perhaps it's going to have disproportionate or improper impacts on surrounding properties, or it doesn't meet the elements of practical difficulty. Things that are not valid, and this is sometimes hard to deal with. If there's neighborhood opposition, if you get a room full of people that come and say they're opposed to you approving something, that's hard to deal with. NIMBYs, that's often where we get the neighborhood opposition. Or if you, it's a use that you just don't want to see, or it doesn't reflect your values. Those are not valid reasons to deny something. You need to rely on what's in the ordinance. And if you think that the ordinance is allowing something that you don't want or you think is improper, that's the time to change the ordinance so that it reflects what your values are and what you do want to see there. But basically, you're bound by what's in the ordinance. So the last thing that I will leave you with is that because you need to follow the rule books, you can't always vote the way citizens want you to vote. So if you have a public hearing and you have 50 people come and speak out against something and 2 people speak in favor of it, that does not mean that you need to vote the way the majority did. You need to vote the way the rule books and the criteria tell you to vote. And that's important and not always easy. So with that, I'm done, and I'll take any questions that you might have.
I would just add one thing.
Sure.
You can't always vote the way that you want to vote either.
Well, right.
I know that,
Yeah.
I can't recall the situation, but I know that there was a situation where I voted for something that I was against because it fit within the bounds of the law.
Right.
And the ordinances. So,
Exactly.
yeah, I was forced to say, yes, go ahead.
Exactly, right. So just because something doesn't fit with your values or what you want to see doesn't mean, yeah. And that's when, you bring it up with your city council member and say, hey, I don't think this is right. Maybe we should consider changing the ordinance. And you have a discussion about it.
But isn't that why we have so many people here? So you can, if you do strongly feel that way, you can vote no, because the other 5 will say yay, and that'll be, but you are voicing to the city council, because this is just an advisory panel, you're saying to them, I don't believe in this, and we need to maybe look at this a little tighter. So by not necessarily in that situation, you could have said no, and they would have heard it at the city council, and they would have said, well, why did he say no?
I would respectfully disagree with you, though, because the law doesn't allow me to say no. If the applicant is fully within the bounds of what our ordinance is and everything says, what I'm arguing is you are compelled to, it's almost like if it's allowed by right, even if, I see it a lot, when Hardee's was coming in, I saw a lot of comments on Facebook about, we shouldn't let a fast food restaurant be there. Well, it was an allowed use by right, as I recall. So even if you don't like it, the law compels me to say, yes, I vote to approve that, because the law allows it.
Right.
Sure.
And I
But there's
think,
a lot of gray areas too. Like we had one that came through that was a gun, a gentleman wanted to put have guns sold out of his,
No, it wasn't sold, transferred.
right, well, it was,
There's a big distinction, because he was taking no money and
he was taking no money. I don't remember that part.
It-
At any
it's-
rate, there was a lot of controversy about it. And there was a gray area. It really wasn't, there was not really, yes, this is in the boundaries of it.
sure.
It was because the federal hadn't come down yet, but we didn't really have an ordinance against it. So we had to let it happen.
Sure.
But they were counting on the government to come through and say.
Actually, I know, well, this is one of my,
That's the one that
I
you
distinctly
came in.
remember
That's
that. I
when you
knew
came in.
this is
That
the one
was
you were
your
going to
first
call.
day.
But in that particular case, it was actually state law as well. This had gone through state committees, and this was how they wanted to handle the transfer of a weapon legally.
Okay.
So it was defined by the state law as well.
But I
So it
think,
was, so it was a distinctly different one. But you did have this, Commissioner Campbell's comment on number 54, the use does not reflect my values, is not a valid finding of fact.
Right.
So that's
So-
how the question is answered.
Right, I think, there are gray areas in the criteria though, certainly, because they talk about, fit with the surrounding area and compatible with other properties and that kind of thing. And that's, so some of the criteria are subjective, and that's why there is a planning commission, because if everything was cut and dry, we wouldn't need you for anything. But in general, if something is a permitted use and you don't like the use and you want to vote against it, I would say that's something that you should, and you're legally obligated to vote for. But if you don't like that the use is allowed, you should absolutely talk to the city council who appointed you, raise this as an issue, and hopefully get it addressed. I don't think a protest vote is the way to do that. A conversation is certainly the way to do that. All right. Well, thank you very much for your attention. I hope it was helpful, particular to the new guy. And if you have any thoughts or questions, as always, ask staff. That's what they're there for, and I'm always around through them too.
Are you going to be around after the meeting?
I'm going to run out of here right now. No, I'll be here.
Good, because I got an off-topic question for you.
Okay, very good. Thank you.
Thank you, Erin.
Okay, next item is the planning and development update.
Oh, right, okay. Yes, a few items here, I'll be pretty quick. Just a few items looking ahead to the June 14th City Council meeting. Tentatively, here's some of the items that we plan to bring forward to the council. The Forefront Campus, the PUD and site plan amendments, they want to move forward with commercial and retail without the residential component, actually. We also plan on bringing forward the final plat and site plan modifications for, this is impact apartments. They want 7 additional units as part of the apartment complex there. And the final thing is the Willowbrook 6 edition, the final plat, again, tentatively on the June 14th City Council meeting. Just a quick question, actually, the chair brought this up. Anyone on the commission ever taken the training through the League of Minnesota Cities commissioner training by chance?
I have.
Familiar with it, but no.
Okay. That's just good to know that a couple folks have, but the majority.
One of the reasons I brought it up is because in the past, when I came on the council, they asked me to do it because there is a benefit to the city of some kind. I don't recall what it was. If a certain percentage of the people on the planning commission have taken the training, because it's part of their insurance policy.
That does sound familiar to me.
Yeah.
Wow.
So it would be probably good to get the information. It's a at-home class. You just take it over the internet and take their quiz and test, and it's pretty easy.
So I'll look into the details, see if I can find out more and report back to the commission.
And just to get myself in more trouble, you might want to check and make sure that if there's a sunset on the training, if, like, I and Lee need to take it again.
Right, okay.
Like a refresher.
If there's a requirement of every few years.
Last thing I have is just looking ahead to next month's meeting. We do not have any active applications on file, so to be determined if there will actually be a planning commission meeting in July, and that's all I have. Thank you.
Thank you very much. Last but not least, Commissioner Swedberg, do you have any city council update? Councilmember Swedberg, I'm sorry.
Yeah, that's all right. Hi, you guys. Last but not least, but not last, I should say. Anyway, if you have not been to the new home in Oakdale, it's just opened up last week. They have the Sleep Express there. Luke, you got to tour it with it.
Yeah,
We got
fantastic.
yes, it was gorgeous, wasn't it? I mean, it's like a destination in there, you guys. It's huge. You have home furniture, of course, and then you have Sleep Express. You have Seasonal Concepts and Dock 86. And it's just huge. It's so nice. I would recommend anyone stopping in to see it. And I don't even have stock in it or anything, so I'm just saying that it's nice. So I just wanted to bring that up to stop in. Another thing is, I am part of a landscape revival, and this is besides that I'm on city council, so it's nothing. I've been on landscape revival for over 10 years.
So we're having the native plant sale this Saturday at Fire Station 1, 5000 Hadley Avenue North. And it's from 9 a.m. to 1 p.m. And there's going to be 6 growers there. And we have exhibitors also there. They're going to be inside the fire station. And you learn about bees and pollinators and milkweed and all this other stuff to complement a healthy community. So anyway, I just wanted to bring that up if you're interested in coming. It's there also is going to be a food truck there. Great. It's the guy that's usually at Oscar is his name. He's usually at the food truck on the outdoor market, right? Yeah, he was there last night. So he's going to be there. So great event to come to. And I think the weather's actually going to hold out too now. It used to say it was going to rain, but now it's saying it's just going to be cloudy. So great. Other thing is Summerfest, in case we don't have a meeting in June, to make sure you guys come to Summerfest. That parade is on the Friday the 24th, I believe. Is that a Friday? I don't,
Yes,
right?
it's on Friday, 24th.
Okay, all right. So it starts at 6 p.m., the parade does. So encourage everyone to come to that. And of course, on June 25th, we have the big Rocking Hollywood's playing, and they've had the fireworks, and they're going to be bigger and better than they were before. So that sounds good. We have lots of food truck vendors coming, and there also we're going to be selling non-food stuff. So we have several applicants selling that. So I would encourage everyone to come out to Summerfest this year. And lastly, just heard the news about Emily, that she is now not going to be joining us anymore. So I want to wish her the best of luck and thank her for her time on this committee. So her family obligations took precedent, of course, and they should. So, but I enjoyed working with Emily. So anyway, any questions you want from me? And Lee, I appreciated you asking about the church. Yeah, and the parking situation. Anyone else have any issues? Everything's great. All right. Thanks a lot, you guys.
Thank you, Colleen.
Yeah.
That brings us to the last item, adjournment. And don't know that we actually need to vote on it, but
I'll make a motion to vote. I'll make a motion.
Second.
second, all those in favor?
Aye.
We stand adjourned. Thank you.
Thank you.
By Robert's Rules of Order, when you come to the end of the agenda, you
Yeah.
are adjourned.
Yeah, that was my understanding as well. You don't need to vote on it.
We vote on it.
You can just say meeting adjourned and that's it.
We've always done that.
Yeah, everybody's always done it, but it's not really required. Okay,
Starting a new trend.
no. Used to be you had to get attention of the chair.